Bederow has a number of items as well.
Mr. Bederow.
Thank you, Judge.
Honestly, go fuck yourself, sir. You don't say that, okay? You don't lose a trial where a jury acquits someone and finds them overwhelmingly not guilty and say, I gave my sincere obligation to look into this, and I'm telling you all I saw when she's guilty. Again, respectfully, go fuck yourself.
Swear again like that. That was, no, I mean, whatever. That was, I shouldn't have done that.
A few moments later.
You, as a prosecutor, have got to be out of your fucking mind.
Nose.
Dude, Jimmy, look at those ears.
The ears don't bother me as much.
No, I don't trust a man. I don't trust a man with a lobe like that. No,
really,
not a fucking chance.
The mouth is butthole to me.
Very thin, paper thin.
The nose.
Oh, the nose.
The brows.
Well, listen, I will tell you though, I kind of like a fucked up nose on a guy.
Like a big old honker. Like a big nose.
Old nose. Give me that beak, bitch. You know?
Yeah.
Like, I'm into it.
Come over here. Cluck, cluck.
Yeah.
I see some chickens that went moving on up in my biz, cluck, cluck, running. You gotta be with the kids, the kids, the kids, the kids, the kids, kids.
And I go, oop, clutch, clench, kegel. We did it all. And I go, oh, and what happened? And they go, well, we just got 4,000 plus pages, bitch. And I said, stop it. Show me it. Take me to Unimpound Town immediately, if not sooner. So what happens?
The bitch is here.
Why are you at a football game? Are you a Fonz correspondent?
Well, no, because it's only for men over 30. Okay? Have a great night, boys. Fuck off.
It's been 1 week since you looked at me.
Hey, Blues Clues, motherfucker.
Good morning, loveys. Happy October 19th, 2025. And we are together again for Sunday service. Today we are brought to you by the color green, the Boston Red Sox, and our favorite emotional support attorney, Mr. Mark Bederow. He is here. I was not late. I am not crying. But I hit myself in the eye, and then I had mascara on from last night. Don't judge me. It started to run down my face. So we chatted for a second, but he is here. Let us pray. Hello, Mr. Bederow.
Hi. So 2 things. One, you were a little late. Let's be honest. Maybe a minute. And
not like late.
So I never really watched that intro because it's embarrassing, you know, with the whole no swearing.
I'm taking it down then.
But no, don't take it down. I watched it. And did I hear correctly that to go with the clenching or whatever, did I hear a reference to Kegel? Did I hear that correctly?
Yes. Yes, you did.
Watching this.
I say we clutch, we clench, and we kegel. It is, we clutch our pearls, we clench our butt cheeks, and then, hey, it all works. The Lord works in mysterious ways, and so does the clenching for thee.
There's a lot of estrogen going on in this whole thing. Okay. I just wanted to make sure I heard what I heard. Wow.
Oh, you heard it.
I heard it. Okay.
Yep. That was not, that wasn't a little bit of a trick ski. Okay. So what a week. What a world. And, I haven't seen you in 2 weeks, and it is just a pleasure. I appreciate you. You are somebody who gives a voice of reason. You are somebody who is basically the legal expert that helps us, the common folk, just the commoners, the peasants, break things down, take a breath, and it is priceless in my opinion. You are also a friend, but don't toot your own horn, Kim. Beep, beep. Okay. So this is, it has been quite the week, and I wanted to get into a lot of different things, but the topic that is on everyone's tongue, if you're aware of it, is a motion that came out on Friday regarding the Miles King case and Trooper Michael Proctor's text messages.
Okay.
And a wee bit of a mistake that he made when he believed that he set his messages to expire after 30 days, and it ended up actually being that they were saved forever. They were saved forever. And they have received.
Cloud is a dangerous thing, I suppose.
Yes, go tell me, what are your thoughts on that?
We have to wait and see, clearly. I mean, I guess the first thing you would say is anytime that guy makes any representation about anything, I wouldn't believe it without independent corroboration. I don't believe his lawyer was lying. I think lawyers sometimes rely on representations of clients. So it turns out that there's all this stuff that goes back 12 years, allegedly, that they have to sort through and decide what's discoverable. My understanding is they've acknowledged that some of it is. I don't know what that means. Discoverable doesn't necessarily mean helpful, right? I mean, there are things that you may have to disclose that may not be useful. They may not be exculpatory. They may not be relevant to what any particular defendant wants to do. But the fact that he would, in theory, make a representation that would turn out to be not true is about as shocking as, 2 + 2 is 4. I mean,
right.
The man is a scumbag. So there's just, I mean, if he told you what day it was, would you believe it without looking at a calendar and having 3 other people tell you what day it was? I mean, I wouldn't. So you'll have to wait and see what it turns out. I mean, we're going to look into it. It could impact us, in our cases. It certainly apparently has some relevance in Walsh. It clearly has some relevance in King. It'll be very telling to see if anything turns up that ought to have been disclosed to Karen Reed during her thing. There is a civil trial, and Proctor is, we're told is going to be a civil defendant in that case soon. So there could be all kinds of repercussions for this, but it's early. We don't know what it is. You just have to wait and see how it shakes out.
Absolutely. And it was interesting because, again, I had just seen that part of the motion and what Melanie, our friend attorney Melanie Little, had discussed on her show. But that it's important to make the distinction that it is not related to the other items that were produced that came from another agency, that the other agency could either that they could either delete or not delete or turn over. That has nothing to do with that. This is completely different.
They're screwed on this being discoverable, because if there is evidence that is in the possession, custody, and control of the DA's office that has nothing to do with the Justice Department, then it's in their possession, custody, or control. There's no protective orders or anything like that. I mean, and I don't know if this is personal, whether it's his work phone, this and that, but if Proctor has information about these cases and he's a state witness, which he clearly was at the time, they had access to evidence on his devices. That has nothing to do with the FBI,
right,
or the U.S. Attorney or the Justice Department as a whole. So, there's all kinds of different things going on here. If they have information, meaning the DA, that is discoverable, that's in their possession, custody, and control, then they're obligated to disclose it. And frankly, they're obligated to disclose it irrespective of what a federal protective order says, which is kind of the trouble that I think you saw over the summer, where one of the judges was scratching his head saying, well, what do we do? I mean, if you're in possession of evidence that the defense is entitled to, but you're saying we can't do it because the Justice Department won't, then you are in violation of your discovery obligations. It may not be venal. It may not be, intentional in the sense of we're trying to hide, but there would have to be consequence if you don't disclose what ought to be legally disclosed. And, this is all just another example of the general shit show that surrounds this DA's office and all of these cases and all of the fine, upstanding characters that they use to investigate these cases and, frankly, jeopardize these cases.
Absolutely. It feels like it feels as though I am watching a bad movie, and now it is happening in other counties, but Norfolk County, to me, just from what I have knowledge of, and I can't know about things I don't have knowledge of. I know I get like emails, or I have seen other cases come up in different counties that everyone says, "Hey, Kim," and I'm very well aware that this is not a Massachusetts problem only. This is everywhere. It's just impactful because I'm aware of what I am aware of. I would like to speak on when we have the facts and we move forward in a, very educated opinion way. We don't just lay things out here and say, oh, this is only opinion based. This is all documented. This has been in multiple cases, in multiple trials, in multiple settings that I'm expecting to see someone do justice, and I'm not seeing it in places that I am offended, like for our communities, for our constituents, and for the Commonwealth as a whole.
The only thing I've ever seen remotely similar to this was in Brooklyn, New York. They've kind of fixed themselves, but they had a crisis for years where they were essentially the poster child for wrongful convictions, certainly in New York, if not nationally at the time. But the stuff that's going on in Norfolk is just, it's insane, because it feels like every serious case is just completely jeopardized, tainted, lacks credibility. You never want a prosecutor's office or a justice system in a particular county in general, to just look this bad or be such a laughingstock or cause the public to just have no confidence in what they're doing. And when you see what's going on here, you look at a guy like Brian Walsh, who, give him due process and all disclaimers apply. The guy is almost certainly factually guilty as hell. Based on what you've been told. And, that's not a basis to convict him, by the way. You still have to try it in the courtroom until the evidence comes in. But, we're just being common sensible and reasonable about what it is. And there are all these problems that have been created. This King case, which I don't know much about, but it wouldn't be shocking if he was factually guilty, and overwhelmingly so. And that case is even more of a mess than Walsh, I would imagine.
Yes.
With problems all over it. You saw how they just completely butchered the Birchmore investigation. Clearly, everybody knows the fiasco that surrounded Karen's situation. Won't get into too much detail about the fiasco involving someone else's ongoing legal battles. Mm-hmm. But every case that they touch that appears to have any public interest devolves into just a fiasco, which begs the question, what about the little cases, or the cases that don't have any attention? This stuff is going on publicly. What do you think is happening privately? I'd be worried about that.
Yes. Yeah. And I think that everybody is. And that is where it is so important. And it has been so refreshing to have somebody like you specifically, Mr. Bederow, who just understands, because we can look at it and even on a educated level and say, okay, now this common sense doesn't make sense to me, but you break it down of the fairness aspect, and you always call balls and strikes. And that is where I look forward to you, because it's not just a side. It is always the truth and what is right, and what our law always, indicates is where you will go.
If you want to see, one example of the many, which I think is indicative or illustrative of the crisis that exists in this place, it's the testimony from a month or two, whatever it was. It's that Lally testimony in the King case.
Yes.
The complete indifference over disclosing search warrants to a murder defendant over the course of years, such to the extent that a murder defendant had to be released from custody. Okay. And then there's a real important hearing about it. And there is just this complete lack of intellectual curiosity, sincerity. It's just breathtaking indifference to what be doing, and a shrug of the shoulders. And everybody sits there and watches it. It's not the sexiest case, obviously. the only reason that anyone is interested in the King case is because it's Proctor and Lally screwing it up. This would be a case that would otherwise be in the dark, but for light being shined on Karen's case, because you wouldn't know who Michael Proctor was. You wouldn't even know about this. But that moment of everything you've seen, even more than like taillight pieces and this and that, just in terms of, wow, this is insane. And these people really don't get it. They really don't care. They have no mechanisms. They have no best practices. And there is a culture of just rot in that place. I think is that hearing is to me the watershed moment of, man, this place is screwed up.
Yeah, the complete lack of urgency, like you were saying, and or accountability. And like, I played hot potato, I transferred it to this, and just not a, like, for not only for the victim in the case, but also for the defendant. These are humans. I understand. And for families, and for, like we've said, even the people in the community that live and see and are watching what's happening. Where is that faith or the trust in you when you can hear such blatant disregard for policy and protocol, for any, like, I knew, I said I'd look for it. He said he'd give it to me. Yeah. Like it just, that was wild to me in that Lally, moment.
But to me, the most absurd moment, and I mean, again, just as a lawyer who deals with this kind of stuff, it's just incomprehensible, is when this guy says, well, and I'm paraphrasing. So in fact, I watched it once, but when he said, well, he gave me, like 3 pages out of an 8-page warrant. And then he's just like, all right, I mean, are there other pages? Why are you giving me this? How do we do this? Did you give that over to the lawyer? What did the lawyer say to you when they only got a cut? I mean, there's just a complete lack. I mean, the only word is just a conscious disregard and complete indifference. And this is the guy who tried Karen twice with the detective who was the lead. He won't tell you this, but he did say it in other places. The lead investigator of that case, and is mixed up in all these other cases. And this is after all that craziness comes out about Karen. The DA's office puts him up to testify, and he testifies in a way where he just doesn't care. It's as if he's just thinking about, am I getting roast beef or corned beef for lunch? I mean, it's just insane to me.
It goes back to it's time to make the donuts, right? And it's like, but those donuts are bad. You got to go and redo the recipe because you're making people sick. The
problem with the donuts is you're talking about life sentences, taking potentially dangerous people off the street, or, from the other perspective, potentially sending someone who maybe shouldn't be in prison for the rest of their life, potentially to prison. But one would think that when you are charged with that level of responsibility about protecting the public from potentially very dangerous people, or protecting the rights of somebody who may not be factually or legally guilty, that you would have a seriousness of purpose.
Yeah.
And at least the way that office, or certain members of that office, seem to operate, and I include the state police in that, is anything but a seriousness of purpose. They can't even find out where a search warrant is and turn it over. And I mean, can you imagine being, and again, I don't know what King did or didn't do, and frankly, it doesn't really impact me. I'm just looking at it from an outsider's perspective. But, somebody got murdered, and there's a family of that person who I assume is very convinced that this King guy did it.
Yeah.
And they presumably want justice, whatever that means, which I assume in their eyes means that this man should go to prison for 25 to life, or whatever the Massachusetts sentencing structure is. I don't even know off the top of my head. And then they find out that this guy gets released from jail because these people can't disclose for years search warrants in a murder case. And then when there's a hearing to get to the bottom of that, the prosecutor is basically, Sergeant Schultz from Hogan's Heroes. I know nothing. I know nothing. And all roads lead back to Proctor, who of course is the, literally the albatross, right? The guy who has just destroyed the place and who's now being dragged back in because all of a sudden his phone records, there is more despite what he said.
Oh.
I mean, it's so embarrassing, but more than that, it's really upsetting because how does anybody have any confidence in what these people are doing, good or bad?
Right. Good or bad. There it is. That is the origin or the peak of, or where it comes down to is, I have questions about everything, whether I think you did the right thing or the wrong thing, because what we have seen and what the small amount of the curtain that has been pulled back has been more atrocious and more atrocious in each example we see. So
It is.
yeah,
You also have to remember too, these are their, not to quote Indiana Jones, but like, top men, right?
yes,
People. But, Lally prosecuted the highest profile case they're ever going to have twice. King is a serious murder case. This guy is a top guy in the office. Proctor was a top detective. I mean, that should scare the hell out of everyone. That these are the people in charge of the most serious things. And God forbid you're on either side of a very serious case, whether you have a family member who was harmed or whether you have a family member who was accused. I mean, why would you think that this is going to be handled properly just based on the evidence that you see in open court on multiple cases by the same people?
again and again. It's like it's bullshit, rinse, repeat. Bullshit, rinse, repeat. And the fact, when you were just saying that too, is that there's 12 years, or I'm just saying with Proctor, is that I knew that he had, like, literally, allegedly a 12-year, and detractors would say he had a squeaky clean record, nothing before anything was introduced into Karen Reed. And I say, oops. Well, you just bit your nose to spite your face on that, because if you were doing dirt, and I always said this, the behavior like I saw on that stand from just what happened in Karen's case, which I felt was such a wildly inappropriate on so many levels, a coercion of a medical examiner or attempt of it, right, to twist her arm, which was the most upsetting to me in his testimony, but to text the people in which he did, to say the comments in which he did, to be using medical diagnoses of a defendant and against them in a private and despicable manner. That didn't happen overnight. And I know because why. In my opinion, the balls to do that was, creeping, like, and it got more easier and easier to do things like that. And when it happened when he was doing that in January of 2022, texting his 9 best friends from first grade, what he did, all I was thinking was he didn't even think twice about it. I believe.
I mean, look, anytime you want to, give him grace or give him the benefit of the doubt, I would just simply steer people to his 2020 interview or Dateline, whichever one it was. And when given the opportunity to eat this, or at least, I mean, he went on ostensibly for the purpose of reputation management, right?
Yes.
Why go on? And when push came to shove, play the video, rewind it, and watch it again. The guy said, investigatively, I wouldn't do anything different. That's all you know about him. And I wouldn't send the text again and it was inappropriate. Forget all that. I mean, that's just gross and shows you about who he is when no one's paying attention. But as a detective, he thinks he conducted a great investigation and wouldn't change a thing. That's all you need to know with this guy.
Yeah.
That's it. There's really nothing else to be said about him. He thinks it was a great investigation. Karen's case.
Yes, delusions of grandeur, if you will. Okay, so yeah, with that, I 100% agree with you, Mr. Bederow. Thank you for breaking that down for us. And when we look, how up are you on Kelsey Fitzsimmons' case at all? May we speak of that at all?
We can. I mean, I'm not as up to date on the little things. We can do that. I need to go take a coffee break though. I'll be right back.
Coffee break. Loveys a coffee break.
Right back. Give me a
We'll
minute.
be right back. Ready? Watch, guys. Do I have anything? Watch this. Oh, I love that. Go take it. Does anyone have a little pee-pee that they need to do? A little pee-pee. I could say, oh, I baked you Sunday. Sunday baking equals little Nurse Kim's shut the fuck up cakes. This is going to be great. I love a caffeinated Mr. Bederow. And I'm going to throw just a 30-second wee bit of a song for us. Hate that. Woo! We're dancing, divas. Techno. Techno. Can you feel the beat? Woo! EDM in the morning. You can't tell me anything.
What are you doing?
Oh, sorry. We did an interlude. I apologize.
I just want a coffee.
Oh, please. Oh, media assets. Get this off. Oh, my Lord. See, this is why I shouldn't touch the buttons, Mr. Bederow. How come this won't leave now? We have just shut the F up cakes. I am going to. Oh, my gosh. No, seriously. Where is it? Oh, my Lord. Remove you. Oh, gosh. This was a poor choice. Here it is. Found it. Okay, good. Hi, we're back. Cup number. What cup is this now?
This is the end of the pot, so this is probably 4.
Woo! That's my guy. What is this? What is the brand you said you drink in the morning? I'm sorry.
Right now, Zabar's, which is like classic New York. I don't know. People probably get so sick of hearing about all the New York stuff. It's an old school kind of gourmet food market on the Upper West Side of Manhattan. It's been there forever. In fact, the guy Saul Zabar just died like 2 weeks ago. He was like 90 something. But
his name was Saul.
Oh yeah, no, it's as oy vey as it's like classic.
I love that.
But they have incredible coffee. I mean, they sell a gazillion bags of coffee a week. Fresh cheeses, meats. It's like your classic. If you know New York, it's similar to like Cinderella. If you know that, it's the same idea. And they have a bunch of these on the Upper West Side, which are just. I used to live like a block from there.
Better call Saul. Saul's a bar.
Well, you're up.
Yes.
Yes, and Saul Goodman and Saul Zabar. How about 2 Sauls?
Yeah, Zabar, yes. I'm like Zanzibar.
No, they're very well known for their coffee. You can mail order it, and I recommend you all order
non-sponsored.
Non-sponsored. No, I get no payment.
Oh my gosh, I love that.
I'm not grifting for Zabar's, I assure you.
No, not at all. And I also would like everyone, reminder, get some Kiss press-on nails, non-sponsored. I love these. I do press-on nails all the time. Coughing it, baby.
Listen, if you go to New York, Broadway and 80th Street, okay, go to Zabar's. Go to Zabar's. It's good.
I'll be there. Okay, so great transition, coffee break central, and now into Kelsey Fitzsimmons. This, I know that I just wanted to read to you. So you knew about, I remember we had talked about the hearing that we heard the audio of, and you were like, whoa, right? And I was like, whoa.
Terrible. Yeah, terrible.
Yeah. The motion to reconsider gets put in by Attorney Bradel, and it's denied, the one that goes right to Judge Kathleen. Then they do the SJC relief repeal, right? And we get this ruling this week, and it broke my heart. It's denied, okay? And it broke my heart because of this. So I just wanted to read to you the bottom lines, and then you break it out to us. So it says, contrary to the suggestion in the petition, the judge did not revoke the defendant's bail pursuant to General Law Code 276, Section 58B. Rather, pursuant to the last sentence of General Law Code 276, on the motion of the defendant, the court reconsidered the bail order and concluded that because of a change in circumstances that had arisen, the defendant's inability to comply without intense pain with in-home scram testing, alcohol monitoring, a condition of release that the court viewed for reasons stated in the court's order as critical to reasonably assure the safety of another person in the community if the defendant were to be released on home confinement. No conditions would reasonably assure the safety of the named person in the community. As the Commonwealth's note, nothing prevents the defendant from requesting relief pursuant to the same provision if and when the defendant can make a showing that circumstances, well, it says something that circumstances have changed, because I, of course, didn't have the second page like a dumbass. But so they're saying that the SJC Justice Dewar, who's a lady, by the by, which I'm like, oh my God, these women, what are we doing? I don't know. I just feel like grossed out by it, in my opinion, whatever. But so she says no go, right? And it's only the single panel of the justice, not the whole panel that you can request if necessary. But they're saying in that it was because Kelsey said that she couldn't do something, but that's not true. They just asked for an alternate and she complied. She wasn't revoked. She didn't, she didn't not do the scram testing. They had just simply asked for an alternate option if available. And she was remanded to prison. Thoughts?
So, I mean, the ruling, I mean, it's gutless. I mean,
yeah,
it's wishy-washy, but here's the other problem. And anybody who does appellate practice knows this well. One of the big disadvantages when you appeal anything, if you've lost below, is that any appellate court is going to show great deference to the factual findings of the court below. And only in the rarest of circumstances, if they believe there's an abuse of discretion, or they do a de novo review, which they don't always want to do. Long story short, almost every time an appellate court is going to accept the facts from below and analyze whether with those facts, the law was applied properly. And so what this judge was doing is saying the court below found factually that the dangerousness analysis required this, and I'm not going to upset that. That's the gutless part of the ruling, because obviously this woman should not be in jail over this ticky-tack nonsense.
Yes.
But legally, I'm not surprised at all. I mean, that's how appellate courts often work. However, then the court kind of throws a lifeline, which says, just do the test and, she ought to be out. And I imagine ultimately that's what will happen, right? I mean, you just have to grin and bear it as best you can. If it comes down to, having a hard time doing it, but the difference is incarceration or not, then it would be absurd to keep her in jail if she's able to do it. So, I mean, either way, again, it's just a bad example of the process failing, because you can get into the whole, ticky-tack interpretations, factual findings, and this and that. Sometimes the law is just not practical. And this is an example of this is just absurd. I mean, that this, and again, I have no opinion about her guilt or innocence other than the charges were reduced. There appear to be problems, and that whatever. That's for another day. But this whole issue with her release or non-release on being dangerous or not is just embarrassing. I mean, it's not just.
Okay, now forgive me, Mr. Bederow, but I saw that they're throwing the bone of saying, just say she'll do the scram testing. But here's my concern. She didn't say she couldn't do the scram testing. They said it was pain, okay? But why couldn't Judge Kathleen have just said, with her judicial, temperance and prudence, say, Kelsey, Mr. Bradle, if you are unable to comply with this testing, then I am going to remand you to prison, or give the option to, or you can continue to do this up to 4 times a day as, required by probation or as I ordered, and Judge, Officer January will continue to get that from you. That wasn't an option. It was not an option. They asked for a change, but she never had failed to comply. She didn't miss anything. I don't understand.
Well, nobody does. The judge is terrible.
But why would Bradle have to put in another motion that says, just kidding, we'll do it. Please let her out of jail. She should have, that's insane.
Because at some point you do whatever you have to do to get somebody out. I mean, you can argue the judge is wrong and this and that. At the end of the day, if the judge is the one that's holding, the jail key to swinging open the gate of getting her in or out, at some point you have to be practical as opposed to principled, if you will, right? I mean, you're trying to get her out, and so you just do whatever the hell it takes to get her out. And I mean, look, I imagine they'll do something that will end up getting her out, but at what cost? It'll end up being over a month. Who knows what kind of medical treatment's been missed and damaged, psychiatric
surgery missed,
physical damage, surgery missed. You can't really prepare a criminal case with a client who's incarcerated the same way as you can. I mean, there's all kinds of bad things. It's just a bad situation. And, whether on appeal, the appellate judge was proper in saying she didn't abuse her discretion and I accept her factual findings, that's neither here nor there. The optics of this are just a complete joke. I mean, and the real problem is, and let's just call it what it is, the lower level judge's temperament. I mean,
yes.
You just can't help but think that there is a hostility and a bias there, even if her reasoning was accepted by the higher court. I mean, that display for the public to see was just atrocious.
Absolutely. And it was just heartbreaking again to see another instance and such a serious outcome that we have her now back remanded to Chicopee, and which is not helping her heal, which is not, she's not doing that scram testing. And it's just, and like you're saying, for a dangerousness, it is just so out of bounds. Yet you have, let's say, for example, a Miles King who is out on a $10,000 bond, but a first-degree murder defendant. You know what I mean?
Right. But King is out on a ticky-tack bond for an egregious crime because the DA is incompetent or worse. That's their fault. That is, in other words, whatever's going on with Kelsey Fitzsimmons is not the DA's fault at all. Right? I mean, the DA. What?
It's the judge's fault for why she's in prison.
Right. Yeah. The DA, I mean, the worst you could say about the DA in her case is, get some balls and say, Judge, we don't, maybe this is okay. But even that, they're not really part of this battle. But with King, that is 1,000% the DA and state police fault. That's a punishment. King was released because they are incompetent or worse.
But okay, and totally understand that. And it's just, you think to yourself, but the principle of a safetyness, a dangerousness, and ensuring the community's safety. And you're like, oh, okay.
No,
A police officer
there's-
who's struggling gets shot by her former partner, when she is, in postpartum and you're removing her child from her home. She is the only one shot, and she is in the hospital for 57 days and then is in prison. But yes, we have someone who is alleged of actually unaliving somebody by their own hands and doing something, and we'll let them out to a community. Okay.
Yeah, I mean, look, if you're just comparing who's dangerous and who's not, King is alleged of blasting someone on a public street in I think Milton, right? Which is, mostly a nice town, mostly.
Yeah.
Whereas, obviously Fitzsimmons is not a public safety threat, is no risk to anyone, whatever she did or didn't do in that situation. Clearly has, some sympathetic issues that relate to the whole history with her child and birth and all of that. So, yeah, I mean, if you're just going to sit there and say, how does this guy get out as opposed to her, it's a joke.
Yeah. Yeah. It just reminds me, and one of our friends on Twitter on a positive was like, Massachusetts, the Commonwealth of Massachusetts, burning women at the stake since 1692. I've never felt more seen. Okay. Between Karen and Kelsey. And I'm like, oh, we're back. And also, babes, if you want to keep doing this, we're going to start fucking forming covens. Okay. And if you want to see, I'll do some magic and we'll figure something out, because this seems, push us. Our ancestors will help us. So yeah, like it's just wild.
I never would have thought, if you told me a year or two ago that, and this whole YouTube world and lawyers from all over the country who cover stuff, if you would have told me that lawyers, from Florida, from California, from Michigan, wherever, that the gift that would keep on giving, or some would say the grift that would keep on giving, whatever, would be just Massachusetts is just the endless supply of pathetic legal content. I would have told you, if you were ranking the 50 states, that probably would have been way at the bottom. I never would have thought that. But it's happening. I mean, it's like a joke.
Yeah.
I mean, never would have thought that, but that's where we are. And
like the change, and the thing is right, like, so if you call me Nurse Grift, or you call me Nurse Spin, or you call me whatever you want to do, that is fine, because at the end of the day, I know that I only want to be like a voice that discusses things and is looking at something as objectively as humanly possible. Of course, I have feelings. Of course, I have a opinion on things, but I also want to ensure that we are looking at this, because, as always, the sunlight is the greatest disinfectant. If there is shit that has been done in the dark, bring it to light in order for changes to be made, and a better Commonwealth for our children, our grandchildren, and for the future, for all, not just some, for all. So that's why I personally like to discuss this, and to have such incredible guests like you to come on and say, like, yeah, Kim, that makes sense. You're not crazy for feeling that way. What you're seeing is abnormal. This is not, examples of how things are ordinarily supposed to go, or when we're looking to our justice system for that beacon of hope, and to say that this is the fairness. Our system and our country is supposed to be, the best in the world. And what I have seen happen, it's so disappointing.
Well, as another famous Massachusetts citizen from long ago said, facts are stubborn things, right? That was John Adams, by the way.
Oh.
In the Boston Massacre trial, 800 years ago, not literally. But the point is, facts are stubborn things. And when you look at these cases, I mean, you look at Karen Reed, that case was not normal. And I'm talking from the standard of how it was prosecuted and investigated. It's not normal. The Sandra Birchmore, that's not normal. Okay. What happened in this Miles King thing where they just don't turn over evidence for years and a murder defendant gets out of, that's not normal. Okay. I don't want to get too much into detail, but what's going on with prosecuting people for witness intimidation, for kinds of things, whether it be looking in windows or writing articles or saying things that some interpret, excuse me, to be obnoxious, that's not normal. Right. I mean, none of this is normal. And it just, so you're right to feel that way. People are right to just assume something is broken particularly in that county. And the only way to fix it is to like throw the bums out. Right. And I mean, a lot of the state police, I guess, are gone, but until they fumigate the DA's office to some level. And by the way, it has to be said, you can't assume everyone who works there is a bad person. That's not fair.
Of course not.
There are very good prosecutors there. I'm sure privately they're as embarrassed and appalled as the rest of us that this is, just the way we would do this. But clearly the elected district attorney needs to go. Clearly certain people who have been prosecuting high profile cases and not disclosing evidence and doing things need to go. And, we'll see if that happens next year. Although, who knows? We don't even know really who's running, and we don't even know these people that are running in opposition. I mean, they're kind of ghosts, actually, to be honest.
Yeah.
Surprising, but that's neither here or there.
Yeah. I think that's important too. And I did actually reach out to one of the runners, not the Jejuna Perkins, but gosh, I'm
What's his name? Anybody even know his name? I mean,
I do know his name. Hold on, let me grab it from my email. But but my question there would be,
you have to look it up. That's the problem.
Yeah, oh no, I don't know his name. Yeah, off the top. But that is where you question, right? Of how, even if these other people are running, if they get a split vote and they split up, then Morrissey, in theory, with those divided factions, could end up winning based on that too. So we've kind of got to, like, it has to be
if he runs. Who knows? I mean, at some point you take on so much water. I don't know whether he will or won't, but I guess, you don't want to just elect someone whose campaign is "I'm not Morrissey." I mean, that's better, but
right.
What do you stand for? I mean, do you have any idea what any of these people actually affirmatively stand for? I don't.
Craig McClellan.
Okay.
Yeah. Yep. He is a candidate for Norfolk DA.
Okay.
Running against. Well, hopefully. Well, do we know DA Morrissey? He's been awful quiet on his campaign too, though. Like, would he drop out potentially?
Yeah. I mean, you read the tea leaves, right? He's not raising money. He's taken on so much water. How do you defend a lot of the things that he's done? So it wouldn't surprise me if he didn't run. But what I'm saying is, okay, he doesn't run. It's great that someone steps in who is like, I'm not Michael Morrissey. That's a win. That's good. But who are you? What do you stand for? How do I know that you're actually good? I mean, I couldn't tell you a single thing that any of these people stand for other than, I'm not Morrissey and I promise not to be corrupt. Well, that's great. That's good. But who are you and what do you stand for? What are you going to do? I mean, do you have any idea? I don't.
And the thing that's disappointing is that to me, is that I wish that I even heard from, I know that Mike has had on Jejuna Perkins a couple of times and seems lovely, but where's your voice? Like, where's your voice, babe? I want to see it in, like, not on YouTube specifically. I want to see you out. I want to see you with the people. I want to see you telling everyone, like, hey, this was wrong. What did you think? Or not that this was wrong, but like, I would look into this, maybe into an investigation, into the investigation of the investigation. I don't know. Or that you believed that Karen Reed was overcharged, that you believe something, throw something at us that says that you aren't just going to be another cog in the wheel, because once someone gets in, they'll just keep it going anyway.
Well, I mean, you'd want to hear about what they're going to do, what they're going to change. I don't necessarily need to hear her say, Karen Reed was innocent or not. I mean, they have to be careful about, I mean, but it's not exactly a leap of faith or courage to say that the case itself is a fiasco. I mean, it was handled, and it's troubling. The fact that they retried her for murder when, most people accept the fact based on what the jury said, that they acquitted her of murder. And just because you can doesn't mean you should. I don't want to get too much into this, but there's, an ongoing investigation of one or more people involving still from some of the old tentacles of that case. Who would do that? I mean, after acquittal, and at what point do you just say enough? I'm going to use tax dollars in a different way. I'm not going to. There's just say something, say anything other than I'm not Michael Morrissey.
Because just that's not enough, and you're absolutely right. And it's like I sometimes believe that the devil you know is better than the devil you don't know. I don't agree with that in this case. No, this is one case I don't believe.
No, he needs to go. And that is a win if you get him out. But don't be a voting sheep and just vote for someone who you don't know who they are. I mean, if you do that, by the way, I'm sure she's very qualified and good lawyer and all that. I don't know, but still, you don't just vote for someone because I'm not him and then just hope for the best and not know. That's an uninformed vote if you do that, and then you get what you get.
And you don't get upset.
You can get upset all you want, but I mean, if you're just blindly voting without being educated or not voting, then you get what you get. And Massachusetts in particular has a culture of a hackorama. I mean, it is. I mean, even when I was there, I mean, I've been gone a long time, but I mean, everybody knows it's just. I mean, you look at someone like Morrissey, he is the ultimate hack, right? Has he ever worked in the private sector in like the last 40 years?
40 years? No.
I mean, sincerely, I don't know. Maybe he has. I don't think so.
No.
You shouldn't have people in elected office for the entirety of their adult working life. I mean, that's just stupid.
Yeah, I agree. And but I'm also a person who believes in like term limits for things. Like, I don't think you should do more than 2 or 3. I don't like people that have been in politics for 50 years. Like, I mean, come on, please, God, tell us what to do. Get them out, in my opinion. But that's a different topic. I wanted to ask you about there was a Kate Peters hearing this week rather. And it was regarding a HPO on her regarding a Lauren, one of our friends. I don't maybe want to say it out. Oh no, but it was public. Okay. So one of our friends, Lauren, who has been granted this, and there apparently was this hearing, and Kate Peters was going to be sentenced. Okay. Somehow. Now, plot twist. And when I tell you I clutched my pearls so tightly on this one, the judge ends up saying to the Norfolk District Attorney's Office that, like, hey, I'm not accepting this green sheet from you because you were conflicted off this case. Not the guy who was standing in front, but like your office was conflicted off. So what are you doing here presenting me this green sheet, right? And he goes, well, there was never a conflict. It was just an appearance of a conflict. And she goes, and have you provided me any documentation of how it apparently resolved or anything of this matter? And they're like, it was bumbling idiots like I have never seen before, which I have seen in many a case, but for something like this, as straightforward as it should have been, it was like jaw-dropping for me. And that she doesn't have a prosecutor that was appointed. it made me wonder why doesn't she have the special appointed prosecutor that was assigned? Why did the Norfolk DA's office take alleged recommendations, which they didn't provide the documentation of that, and then brava to this judge who said, no, I need you guys to figure out more information, and you can come back on, I think, the 27th to tell me more about it. What do you think about that?
So as far as the merits of this individual that we're talking about, really, I won't talk about her in this forum other than to say,
sorry.
No. I mean, I'll talk about her when I, take my crayons out and write things and under oath in a courtroom at some point, and we'll do it that way. But as far as the case involving her and what you're describing, which I did not see, but from what you're telling me, this is just another example of Norfolk County and that DA's office is just an embarrassing disgrace. If you have an appearance of a conflict, the way real lawyers work is you step aside because you don't want the public the perception of something going on. So you have conflicts and you have appearances of conflict. If there is a legitimate appearance of conflict, you step aside. The fact that, the Norfolk DA reappears on a case after the other, special prosecutor quits, somebody saying disappeared.
I didn't know why. Sorry. Yeah.
And then the Norfolk DA says, don't worry about it. It was only an appearance. Whoever that prosecutor was who said that is a moron. Okay. I don't know who it is, if it's a kid, if it's an experienced lawyer, but if your rationale is let's just do it because it was only an appearance of a conflict, don't worry about it. You, sir or ma'am, I don't know,
sir,
sir, probably should find a new line of work because you clearly have no understanding of the role of prosecutor and how it works, and a complete lack of self-awareness, especially involving a case like this in an office like this where 90% of the public thinks you're corrupt anyway, right? And it may just be you want to push it through and clear the docket, whatever, but to say we needed a special prosecutor, there was an appearance of a conflict, but the special prosecutor quit, so we can do this, so we're okay, we can do it, don't worry about it. You, sir, are a moron and clearly don't understand legal ethics. And again, who sent him to court? Like, who's running the story place? I mean, what is going on in that place? So I don't know, what's going to happen with her case. It doesn't really affect me one way or the other. But the idea that they can be so cavalier about drawing a distinction between an admitted appearance and an actual conflict as if there's no meaning and we can handle one but not the other.
Right.
These people are just embarrassing to the profession, and they just do it on a daily basis. And I don't know who the judge was, but I mean, the judge obviously recognized properly that's not how we do it. Okay. No.
I was actually very proud. Like I had no idea kind of what was going to happen. I just watched it. It was like 12 minutes or something. And I just, I was sitting there and it was so interesting to see the judge, Mr. Bederow, a female judge, another female judge. And you would have been like, you go, queen, because she was just saying, okay, but you're not telling me how the appearance of a conflict was ever resolved. And now the very office that that was recused from this has provided me the disposition of whatever it was, like the recommendations, and I'm not taking, like, hello, you understand what you're asking me to do. And they were like, duh.
Here's the scary part. And this again is illustrative of the problem in that county. You and others rightfully are saying this judge is a hero. I get it, because she stopped it. Where people like me would say, this judge did what any other judge ought to do. And this is like the most basic common sense. Are you kidding me with this? And the fact that they would even put the judge in this position is absurd. So I don't think the judge did anything heroic. The judge just did what any first-year law student would recognize. You can't do this. What are we doing here?
Yeah.
But in this county, you have to feel like, you need a firewall of people to stop the corruption. And it's...
Yeah, and I misspoke. I apologize, Loveys. I said the 27th. It is the 29th per one of our babes in the chat told me. For they're going back to court to discuss, because the judge was again saying, hey, I'll give you a couple of days, figure it out, and we'll get back here. But I'm not comfortable with you telling me that the Norfolk DA's office is providing on this sheet signed by you the recommendations when you've been conflicted off this case, and you thought you were gonna and they just thought boom, 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 it was gonna be no problem.
The judge wanted to be really aggressive and really get to the bottom of it. There's an inquiry here. You could say, this disposition that you're proposing, who proposed it? Did the special prosecutor propose it and hand it to you? Or did you come up with it on your own, Norfolk? I mean, there are unanswered questions.
He said the prosecutor said that I believe, and that's actually interesting too. I believe he said that we followed within the recommendations of what that prosecutor or the special prosecutor had recommended, but still she didn't have. She was like, "Well, where is that said?"
That's what I mean. I mean, again, why would you take their word for it based on their track record, especially when they're just poo-pooing and it's just an appearance of a conflict. None of this matters. Don't worry about it.
Not real.
I mean, look, if that's the deal that the special prosecutor made and they're just regurgitating it, then ultimately, if that's the deal they give someone, that's the deal. But you need to do it in the right way. You can't just do it the way and so cavalierly say conflict, schmoflict, who cares? This is nothing. It's not nothing. And you see what goes on there, and it's just there's just
and why I want to know why now. And of course, God forgive me, I should know this more. Maybe the chat could tell us, why did the special prosecutor quit?
Don't know.
That's weird.
No clue. I mean, I don't know anything about.
I
don't know anything about her case other than she sticks her finger out the window for 20 minutes or whatever. Just not 20 minutes, 30 seconds, a minute.
Oh, she's been terrible to a friend, and done a lot of things for a long time.
Because that's very normal behavior to just drive on and hang your finger out the window. But whatever. That's who she is.
A towel was outside of court that day as well. A towel by the name of Grant, and that towel said, "How dare you, ma'am," to Kate Peter as she was leaving. And then he said, "Ma'am, don't give me the Canton salute," because she may or may not have stuck up her middle finger at one towel.
I'm not involved in I'm not involved in any civil cases, but that's the same towel who couldn't attend a deposition, right?
Oh, correct. Correct. A towel was at court. Just saying. Oh.
I think the towel was in Boston federal court too. When
he was. Oh, okay. Yeah, that is. Wow. Oh my gosh.
I'm sure that'll be a line of inquiry under oath at some point, but it ain't me, babe. I'm not involved in that. So
it ain't me. Yes. And listen, and we just go where they send us, right? For us.
What I always say, I just go, I work here at the pleasure of management. I go where they send me.
And I would just like to say that perhaps your towel has very low fiber count. Okay. And you maybe got it in Chinatown. Got a towel from Chinatown. Jake. Okay. Sorry.
I thought you were talking about like the quality of the towel and the fake handbag.
I was trying to weave.
No, the fake handbags and whatnot.
Yes.
That are on, Canal and Broadway, whatever, are a much higher quality than, the towels. But,
Do you know I got a fake pocketbook one time when I was in New York, and we were going to the Christmas Spectacular with my Nana. My Nana Phyllis, God rest her soul, my best friend in the whole wide world. We would go every Christmas. We would stop it from the Stigmatine Fathers. Shut up. I'd take the bus. It was like it was like a Peter Pan bus, and it was like a trip, right? A day trip. Oh my God.
Oh,
and we would go.
New York's nice. Oh, the Boston, New York quality.
Boston.
Oh yeah, that's high class living. A bus from Boston to New York is.
Listen, she wouldn't drive her Cadillac. My grandmother would not drive on the highway. She wouldn't do it. Okay, when we would have to go back roads to the Cape House. Okay, how about from Waltham back roads to West Dennis? Stop it. It would take me for a long whatever. But we would do every Christmas, all of our family busing, Peter Pan busing for a day trip from the Stigmatine Fathers.
And the Peter Pan, the basement level of the Port Authority, nice down there, isn't it?
Oh wow, living the dream. Anyway, I got a fake pocketbook, and I thought I was probably, I don't know, 16 or 17. And I remember we were on our way to the Christmas Spectacular, and we were doing like something, whatever, throughout the day. We would get lunch, whatever. And I remember getting I don't know if it was a YSL bag or something, and you couldn't tell me
it was not a YSL bag. It was not a YSL.
It was a fake one.
Yes, of course it was.
Yeah, of course. But it was, I know I didn't get an actual one for $70, but it was so, you couldn't tell me shit. I thought it looked so real. It didn't. Now, this is a long, long time ago. Today, maybe they do look really real. But this one that I had, babe, it had the stitching was like bright green, and it was like a black bag. And I was like, I thought I was thought I was something,
You were living the dream. You were the ultimate tourist. You took a bus from Boston to New York, go to a Christmas show, and buy a fake bag. And did you go to FAO Schwartz too and get a street hot dog? Do the whole?
Probably did. Yeah.
Get an I Love New York shirt and
No.
Statue of Liberty thing. No. Okay.
Yes, and you know what? You making me really embrace my white trash is something I will do 10 toes down. Can't tell me anything. I don't care. I thought I was great.
If you don't want to drive next time, take the Excella. Take the Excella. Take the train. Take the Excella.
I don't think they had the train back in the olden days, Mr. Bederow. I was 16 or 17.
They had trains and working toilets and everything back then.
Oh!
Yes, they did. No, the Amtrak's been around since before you were 16. And, the Excella is much faster. Yeah, that's how you do it.
Whoa. Okay, so the shade this morning, I'm catching some strays, and I also love it. And I'll always be just like listen, I am a little bit of a trash bag, and that's okay. You could take the girl out of the ham, but you can't take the ham out of the girl.
Wow, now you're referencing my hometown. Wow. When you took the bus, you said Peter Pan, not like the Chinatown bus. There's a bit there's levels to the trashiness here. You didn't take the Bonghua or the the $10 Bolt bus from Chinatown.
No, it was a whole day trip with the Stigmatine Fathers. This was this is like a church in Waltham, and we would used to do you could sign up, and my Nana and all of the Cotton Tops. It would be me and 68 AARP members, right? And they went to the church, and we would go there. Everyone would park their Cadillacs. We would take the bus, and we would go as a group. And that's how we got there and back, because I don't know, it was just something that they did. I don't know why we did it that way.
They used to have these.
It was just in Waltham.
They had these $10 rival Chinatown companies, and they were hurting each other. They were attacked. There were actual violent acts committed by these rival Chinese bus companies trying to, corner the market on the white trash felony flyer from Boston to New York. I mean, it was crazy. This is, maybe 10 years ago.
Yeah. And also we used to go I didn't go. I didn't actually do this because I was underage, but they also had like the Peter Pan, the Stigmatine Fathers. Every once in a while, they would take you to like either a comedy show, right? You could go into Boston. They do like a Boston night. And then I remember they used to have a Foxwoods bus too. So all the nanas, okay, not just my nana, but all the nanas would have all of their pennies and they would go down and do a day trip to the Foxwoods. So, I mean, I just thought it was cute as a button.
Could be better than hanging out with like, the 80-year-olds going to Foxwoods and big gambling, put a few quarters in the slot machines and go home.
Do you know I used to literally sit with my grandma? Sorry, we're going way off, but I used to sit and play I'd play rummy, like gin rummy with my nana, my nana, Auntie Mary, Auntie Janet, Winnie, and Priscilla would come over, and it'd be all of me and the biddies, and I would be like this, yeah.
Ethel and Mildred, no, they didn't make it.
They didn't what?
Ethel and Mildred they didn't make it.
I don't know them.
You don't know Ethel and Mildred?
No, you're making fun of the names. Yes, I'm picking up what you're putting down. No, it was not. There was no Ethel and there was no Mildred at that house. But yeah, but I always thought, like, are you kidding me? That was some of the best times in my life, was sitting watching me playing cards. And they'd be like, at some point, they'd remember that I had to go to bed. They'd be like, Kimberly, you need to go to bed. And I'd be like, Nana, just one more. Like, let me just, my Auntie Janet be ripping butts at the table, right? Oh, what is the year? 1994. I am living my best life. I've got a cup of tea, all right, with a Lipton's tea bag with milk only, right? Just housing those crap. They used to have these cookies that had like jam filling in the inside of them from Pepperidge Farm, and I'd be dipping. Oh God, I thought I was something. I was 8 years old.
Fig Newtons or whatever.
Well, yeah, but it's like, no, it wasn't. It was like apricot jam. So it would be like these fancy they tasted incredible. Okay, incredible. All right, so that's childhood. Yeah, there you go. Did you ever play cards with your nana?
Yeah, I played. My grandmother was big. Would play. What did they call it? They called it bagel. It's a form. It's similar to like gin in a way, but for whatever reason, it was. And she would have like funny expressions, like playing these games. It's not the hello, it's the goodbye. Trying to win the game or whatever, or breast your cards, right? So no one can see.
Oh my God, I love her. Breast your cards.
Breast your cards. Hold them up.
Breast your cards. I love that. Taking it.
Yeah.
Thank you, Nana Bederow. Well, was it Nana Bederow?
Grandma. No, I call it
Grandma. Yeah. Grandma. Was it on your dad's side or your mom's side?
That was my mother's.
Oh, well, and your mother is an angel who I think is incredible, and also Aunt Bev, the good Aunt Bev. And I would have a blast if I ever could play rummy with those two. Okay, it would be, and I'd breast my cards all day. I'd say, "Oh, not today. You're not getting them."
These were big state games. I mean, family bragging rights on who won a game of bagel. This was important stuff.
The bagel. All right. Well, you're gonna have to teach me how to play. It's incredible. So now that we have sidetracked on, I have no idea how I got there. I apologize, loveys. But thank you, Mr. Bederow, for sharing and allowing me to be a lunatic. So there is another area, or may I? Oh no, I don't. I probably couldn't even ask that to you about. Am I allowed to ask you about anything about phones or no?
You can ask. I'll answer or not. I mean, certain stuff is public, certain stuff is not. Go ahead, try. From
the appearance, not last week, the week before, there was in Aiden's case for Cosgrove to ask for the phones, or to look through the phones of Karen Reed from the search warrant in January of 2024. Now, it upset me because Krupp put his little grimy hands, in my opinion, sorry, that's fresh, but seriously, in this, and he is saying that he was not listening, I don't believe, to anybody. And why is Cosgrove asking for information regarding phones if, in fact, he has taken himself off of recused himself from certain cases, and you have or the team has requested that he be recused in other cases, yet is moving forward in the request for phones that you already had all the information from, i.e. Aiden Carney's phones. Any thoughts on how that went?
Well, I mean, generally, the threshold question, putting aside whether anyone ought to be doing an investigation because there's a legal basis, or just, again, as a matter of discretion, find something better to do with your life than this.
Yeah.
That aside, we have alleged in a public filing that there is a very serious conflict of interest, which precludes the current prosecution team from doing that. That has to be resolved. So that's really the threshold question. Even if you get past that, the fundamental problem, in my view, isn't so much the search warrants per se, but how are you justifying doing this now? I mean, you can't ignore the procedural history. Okay. And all of this is in the public record. It's in public filings. There's a search warrant that initially was sought in December of 23 to seize phones that was never executed because they couldn't serve it. Okay. That warrant was renewed in January of 24 and properly served. Okay. That warrant allowed the seizure of phones, perhaps taking of data, but not reviewing the data. Another warrant would be required to actually look at the data. Now, putting that aside, here's where it gets problematic.
Okay.
And I think is the real issue that, again, it's out there, but really needs to be addressed, which is this. They have these cell phones in their actual possession in January of 24. Ostensibly, they have those phones in possession to investigate in January of 24 what they now claim they're investigating in October of 25. Okay? In other words, we think that there'll be evidence of conspiracy to commit witness intimidation, which I don't believe there will be. Neither here nor there. Now, they don't get a warrant to actually retrieve and look at the data. Okay? They don't search the phones, but what they do in March of 24 is go to a grand jury to try to indict without even looking at the phone. That is a conscious decision that they made that is investigatively ridiculous and calls into question, why did you seize the phones at all? And why would you want to look at the phones before you seek an indictment? They made a choice. They decided to go forward and get an indictment without even actually knowing what was on the phone. And that was a choice. And the reason that they made that choice, I would suggest, is obvious in late March of 2024, because something big was going to happen in
Karen.
2024. She's going to go on trial. And I would suggest to you that the reason they did that was they wanted to have her bail revoked, and they wanted a nice big story that the woman who's about to stand trial for murder just got indicted, Okay? Nevertheless, they made that choice to proceed without having any intellectual interest of what was on the phones. Okay? Then they ignore it. And what happens during the time period where they ignore it? After the grand jury tells them to pound sand, right? No indictments. Back then.
Acquitted. Yeah.
Karen gets the trial. Probably gets acquitted at the first trial, but whatever.
Oh. She
goes to trial again, and she gets acquitted for murder either the first or second time, depending on how you look at it. Then, as if they have nothing else to do, because, we have to hunt the great white whale, we got to do something. When all that's over, now they want to investigate an acquitted murder defendant, probably twice, and say, yeah, but now we need to investigate them for intimidating witnesses that the trial jury didn't credit, not fully anyway, for witness intimidation, for phones that we've been sitting on doing nothing since January of 24, We went to a grand jury. They no-billed it. And now we want to try again. But judge, we need to look at the phones first. So this really is not an issue about the phones per se. The issue here is, should they be allowed to go to a second grand jury, search the phones to try to develop evidence when they had it the first time, they had the ability, they had them in their possession, and they made no effort to do it. Okay, this is their fault, their incompetence, their recklessness, and no court should ever authorize a prosecutor to engage in this kind of nonsense where they just think that they have a right to hold evidence in perpetuity and one day wake up and say, well, why don't we just look at it and see if we can indict someone, when they could have done it at any point, but they wanted to rush to the grand jury because they wanted to bang her with an indictment before her trial. And that is prosecutorial malfeasance. Okay, if you seize the phones because you're telling a court, I need a warrant because there's so much evidence here that we think we'll find that will help us, well, it might help to actually search the phones before you go to a grand jury. They should not be rewarded for their malfeasance.
Definition of second bite at the apple, right?
That's how this needs to be framed in the second instance. The first instance is very simple. There's a conflict that has to be resolved. But you should not get a second bite at the apple phones, if you will. No. You should not get a second bite at the apple if you didn't even try a first bite before you were so cavalier and reckless to run to a grand jury without even caring what was on it because you knew that would screw up your timeline.
Right.
No court should condone that.
Wow. Yeah, and that's so malfeasance, that's what we'll say, because like when you are saying, Mr. Bederow, that you've had this in your possession and these have just been there, you made a decision, you attempted to do everything that you could to have Karen Reed's bail revoked if she had been indicted on another charge.
You got a warrant in January of 2024 alleging all kinds of probable cause that there would be compelling evidence on these phones, which we need to prove a conspiracy. Okay.
Right.
The judge says, okay. And you get the phones. Okay. And the prosecution was so concerned about this important evidence that they did what? Nothing. And then ran recklessly to a grand jury because they're fighting against the clock. All of a sudden, the phones don't matter. They get no bill. She gets a hung jury or acquitted. They try her again. She gets fully acquitted. And now, after all that, we need to go back and search the phones and go to another grand jury because we think it will prove something. If you allow that, you are condoning inactivity, incompetence, and no court can condone this. You just can't allow people in power to seize evidence and just do nothing with it. And then one day, years later, wake up and say, let's go look for evidence. When you swore you had a warrant, you had an affidavit swearing to a court that you needed this to prove it back then, and you just blew it off because you were so gung-ho on trying to get her jailed and embarrassed before her trial. It's just, all of this is just gross. And this is not how prosecutors should be behaving. And ultimately, if the prosecutor isn't going to behave the right way themselves, then you need a court to step in and say, I'm not going to allow this.
Yeah. And it just looks to me specifically like the Commonwealth is, I mean, and this has to look to all residents and anybody and millions of people who have seen this case of Karen Reed specifically, that it feels like that the Commonwealth is a dog with a bone, okay? And that they won't give it up. And it looks it looks disgusting from the outside in. This woman has fought for her life times two.
It looks again, we just explained why it looks terrible. But the other thing is, prosecutors have another really important tool in their belt. It's called discretion. Okay.
Yeah.
And what real experienced and seasoned and good prosecutors understand is that just because maybe you can doesn't mean you should. And, you know, if you take a step back and just look at the whole picture and say, she was acquitted once or twice, and we're going back and seeking an indictment of these people for conspiracy to commit
Insane.
after a grand jury said no the first time, but we're going to indict them for intimidating witnesses on a case in which one defendant was acquitted and the other one brought publicity to it and brought public exposure to it. And we're going to call all of these witnesses to say we were intimidated, even though the case is over, and at a time when the majority of those witnesses are going to be civil defendants, you know, in a civil alleged, you know, conspiring to violate civil rights, you know, in the Plymouth County case.
Yes.
There comes a point when, as a prosecutor, you say, why am I doing this? Why am I wasting public resources? Why am I spending all this tax money? For what purpose? Okay. The Karen Reed case, criminally speaking, should be over. Okay.
Yes.
Okay. It's over. Let it go. Find something else.
It's over. Okay. Yes. Tell Tiny Mary and Tiny Jesus. And Mr. Bederow, can I just ask you one thing? This doesn't make sense to me. I looked at the original warrant, and I remember Judge Krupp saying that, which signed by Tully, which all roads lead to Tully, in my humble opinion. But it says
the affidavit in the warrant is a sworn statement of Tully, which is no different than testifying in court under oath.
Oh, okay. Okay, now, but I just, when it says right here though, for the data on any cell phone, can be or may be copied, provided no search of that data will be done absent further warrant or order of the court.
This is where what I was talking about earlier, and this goes to the incompetence or worse. So what the warrant authorizes is the seizure of the phones and the transmission of the data off the phones to a different location like preserve. It does not allow a search of the data. Another warrant is required. They never sought that warrant. They went to the grand jury without doing, all they had to do was swear out another warrant. They would have gotten it, and they could have looked at the data. They didn't do it. They chose to go to the grand jury. They let this sit from January of 24 to October 25. And now all of a sudden we need to go to another grand jury and investigate the same thing we already got declined, but now we need to look at the phones. This is ridiculous. This is not how the criminal justice system is supposed to work. And the fact that they never got the warrant is negligence or worse of the highest order. And you can't allow, I mean, think about what the government is arguing.
Yeah.
We got the warrant, okay, back in January 24, and all we have to do is get another warrant to search it, and we can do it. So October 25, maybe we'll seek a warrant in 2030. Can we look at the phone then?
Yeah, fuck off.
What point is a target of an investigation entitled to closure?
Yeah.
Like this has to end. And it's not even just like they didn't search the phone because they forgot to get a warrant. They went to a grand jury without even trying to search it.
And came up empty-handed.
But they made a choice. They made a deliberate choice. What was the purpose of getting the phone that you needed for the original grand jury to not even search it because you're so hell-bent on getting an indictment ahead of her first trial?
Correct.
That's a choice. That is an intentional choice. It's a reckless choice. No prosecutor should ever run like that. Okay, that's not being professionally responsible. They shouldn't be allowed to come back almost 2 years later and say, now we're going to look at it. This is not how real prosecutors do things.
Absolutely. But in that hearing, correct me if I'm wrong, I felt like Judge Krupp thought that there was that warrant. I thought that he thought, because it was confusing from Cosgrove, because Cosgrove was like, this would be dispositive if that is correct, but I don't know if it's correct of the dispositive nature. And I'm like, what are you talking about? And then Tim Bradel and Buzang said, no, you're wrong, and this is why we've made our argument. But at the end of the day, if you look at that last line in that original warrant that there is not a follow-up to, then therefore, ergo, you had no right to, and it should have been dismissed, or like she should get them back anyway, period, point blank. But without the warrant in order for them to search, then that goes all the way back to the January of 2025 that you chose not to. You made the decision as the DA's office, and now you have to give it back, because no more, no soup for you. Get out.
What I'll say is this, that there's a lot of confusion at that hearing.
Oh.
True. But it'll be dealt with, but I can't, that's not public.
Oh, sorry.
No, it's not you. But so, yeah, I mean, things have to be clarified. But I will tell you, again, because there was discussion about case law and whatnot, this Diaz case that was discussed, it does apply. It does. Okay. The factual circumstances are a little different than Diaz, but to what you just read, the phones were in their custody and required another warrant to search them, and they never sought it for almost a year and a half or more. Okay, that is very similar to a warrantless search, seizing a phone and then not seeking a warrant to search. In other words, the actual facts that were put forth regarding Diaz, which are slightly different, are a distinction without a difference. Okay, they needed another warrant to search the phones. They never sought it. There's no excuse for that. What they did is run to the grand jury, but they never sought the warrant. That is a distinction without a difference, but that'll be dealt with.
Okay. Thank you, because it was just, tickling the back of my brain, right? That I was like, but that doesn't make sense. It seemed confusing, but it was on two different pages from the defense and the prosecution. And that's where Krupp was like, at first he goes, oh, well, this makes sense. He was agreeing, I believed how I was hearing it, with the defense. And then all of a sudden he was like, oh, but if it is here. And then he did like a 180 and was ready to Kazi G it up.
It is entirely normal and appropriate for a judge in analyzing a case to say, well, didn't that case involve a warrant, and how is that different? I mean, I'm not faulting.
Yeah.
I mean, that's what judges do. They, is there a case that speaks to this? Again, the hearing was, all around was a little clunky. I think people realize that, but, again, ultimately facts come to light. Things are clarified. And you go from there, and you just have to wait and see.
Absolutely. And where is the stop clock, if Mr. Bederow, of the assigning of a prosecutor because of the stateless case in your case?
I'm not going to really talk about that.
Okay.
What I'll simply say is
go back and count.
And the judge was very clear that we need to know what's going on that case within the time period.
Yep.
I personally, we collectively raised an issue that this is not an issue that ought to go back to the Norfolk DA. And the judge, I think, understood that, but said, put it in writing. So we put it in writing, not even in crayon, and put it in writing and sent it. indicating why the DA has a conflict. The DA was served with that motion as well because it involves them as well as the special prosecutor. And we'll just have to wait and see. But there are problems with all of these cases because the conflicts are everywhere and they metastasize. The bottom line is, if there is a conflict between a prosecutor and a certain witness, and that witness is involved in other cases than just the one where that witness is the alleged victim, and that witness's credibility is going to be an issue, you can't have a prosecutor who's getting sued by the witness either attacking or defending that witness's credibility. It differs. I mean, I think everybody understands that the conflict, and those tentacles have spread. It has metastasized to beyond that one indictment to others and other investigations. And there's just no way around it. I mean, you can't say we'll deal with it when it comes up and potentially have a trial, and in the middle of trial have a conflict come, and then the prosecutor says, well, what do we do? And have a mistrial. This is an issue that, because of the legal maneuvers that were made by, a witness here, which are as unconventional gets, admittedly, where you sue the prosecutor, you sue the lead detective, and you threaten to sue the DA. Look, that creates a problem when you're involved in all of these cases. That's just,
right.
That's just what it is. I mean, that's not something we created. It's not something the prosecution created, but it exists. So it has to be dealt with.
Absolutely. Absolutely. And I won't ask any further questions on that, Mr. Bederow, because I apologize. Sometimes I forget what is.
You can ask anything you
want. Yeah.
You cannot answer it. That's all.
Yeah, of course. I feel like there is some sort of change happening just in the atmosphere right now when it comes to trials. The more of the public of us that it is public, this is all public knowledge, and the interest of many citizens to want to know what is going on in our legal system and opinions that they are drawing from cases and conclusions of such as we see them fit. Now, there is another case that was interesting, and I wanted to get your take if possible. It's a Corey Richins case, and she's called the Moscow Mule murderer or something. And her husband, it was alleged that she unalived her husband with fentanyl, and tragically they had 3 kids. And then she wrote a book about death, and she became a famous child author. And long story short, though, that there is a lot of media scrutiny or a lot of media attention on this case, and her defense team just went out and did not a press tour, but they went down their local news to correct the record because the media has been so aggressive, and the prosecution has allowed a narrative of her basically being guilty, until proven innocent, versus the other way around in our country. And it is feeling very reminiscent to me of one hostage video from attorney DA Michael Morrissey, when he had just that statement, no questions from the press, put it out where he said that witnesses were innocent and we one person did this. It was shocking then. It is shocking to see this in another example. But I would like to say just to anyone who is watching this, that it's not just Karen's case. And there is going to be, in my opinion, an increase in questions that are asked, but our prosecution and the DA's offices need to be accountable for what they are putting forward. And that, remember, at the end of the day, that it is your job to do justice and not to be settling a score that sometimes it seems in certain cases.
Look, yeah, I mean, this is a problem certainly beyond here, or there, I should say, Norfolk. But I mean, the Morrissey video, from August of 23
Yep.
is one of the most remarkable things I've ever seen. I mean, that was as outrageous a statement by a prosecutor that you will ever see. And then Mello did the same thing. I mean, he gave an interview, after someone else was indicted, saying, he's guilty, and I have confidence that he'll be convicted. I mean, this is just, again, you can only think it's the culture of the place that where they even feel that this is even an option.
Mm-hmm.
Do that. I don't know what's going on in these other places, but the idea that a prosecutor is giving a statement, in essence, defending witnesses, arguing their case, indicating who's responsible, who's guilty, indicating who's credible, who's not, making factually inaccurate statements about relationships between certain now disgraced members of the state police and witnesses, talking about scientific exams with cell phones, which is again another thing you're not supposed to do. Again, the place is crazy, but they do it, and there just appears to be culturally a way that it's accepted there, and there's just a shrug of the shoulders, and you just move on to the next one. But yeah, the more people become educated about it and recognize that they shouldn't be doing this, the more likelihood that it will stop in the future. So
Yeah. And it was just so wild to me to see a defense team, right, coming out and like per their Office of Professional Responsibility, you do have a right. I believe it. Well, I mean, maybe it does vary from state to state, but don't you have a right to fight? Well, not fight, but like correct a record that is distributed incorrectly by by the prosecution, because we are going to have this, this jury pool that is walking in potentially to think this person is guilty based on an incorrect set of facts, and that was provided by that, prosecution.
Yeah, now the rules are complicated about, what they call Rule 3.6, about statements that people can make and this and that. And there is a safe harbor where if there is adverse public attention, a party can have a right to push back, if you will. And certainly, I mean, we see this all the time. I mean, the kind of stuff that is said about our cases, whether it be online or wherever, it's just always happening. But I mean, certainly if a prosecutor is putting out misinformation, a criminal defendant has an absolute right to make statements that otherwise maybe would be outside of the public record or would be considered prejudicial. But, you have a right to protect your client's right to a fair trial. And, if you have to make a statement that is necessary to do that, the rules do allow it. I mean, the simple answer is, if the prosecutor isn't saying things or people aren't making all these statements online, then, there wouldn't have to be so much back and forth by people. But unfortunately, that's the nature of the beast, particularly, in the era of YouTube and the internet and whatever. And you see, I mean, just all the unhealthiness. I mean, we all see it, Jesus, with even in the last few weeks with the stuff that surrounds the Massachusetts case. If there are inaccurate statements being made, people have a right to correct that record to defend themselves.
Absolutely. Yeah. And I was thinking, wow, hasn't that exposed something, all over, when you are seeing that the more people have interest, the more people have questions, and it all reverberates back down to, would you want this to be happening to you? Of course, our judicial system, we need people there are consequences for actions. You take accountability. You must pay for, crimes that are committed. There's nothing that I believe anything differently, of course. But at the end of the day, you do it the right way. What is right, and what is wrong is wrong. And it will be no matter what. It's not bending, it's not bending anything. And when you see these prosecutors do things that are, in my opinion, out of bounds ethically and for their station and position, you question what is going on here and how do other people fight back against that?
Well, what is so astounding about the Morrissey statement from 2023 is if somebody wanted to defend Colin Albert, for example, that person should be Colin Albert's lawyer. Okay. Nothing would be inappropriate if their position was that this person is being unfairly maligned and whatever, for his lawyer to issue a statement and say, you know what, this is bullshit. This is wrong. That's appropriate. Okay. He's a witness in the case, whatever, they can do it. If anyone in the Albert or McCabe family thought that they were being or Proctor's a little different because he's a government person.
Yeah.
Right. But those are the people who should be doing it. But for the DA to be pleading publicly who's guilty and who's not, and who's just a witness and who's a good person is just insane. I mean, that is insanely inappropriate.
And let's be perfectly clear. Colin Albert had an attorney at that time. And at that time, it wasn't a Michael Morrissey. And for you to, I mean, that is that statement that he made was so wild to me. I remember sitting there and just being like, oh, he's trying the case. He is trying the case, and he is in a very specific position right now.
The reason why it's unethical, as opposed to if Colin Albert's own attorney did it, and that would be a totally appropriate thing as an advocate.
Of course.
There'd be no beef. You can agree or disagree, but they're allowed to do that. The problem is when the district attorney does it, he is vouching and has a great position of authority, respect, presumably respect and power, and is telling the public, the future jurors, if you will, I believe she's guilty. These are good people. There is the risk of undue influence, and that the public attaches great respect to the government authorities to do that. That's what makes it unethical. That's what makes it prejudicial to a defendant, is that it potentially is undue influence on people who may be jury members going forward. Whereas if an attorney for someone who's a witness in the case wants to scream and yell, well, that's their lawyer. It doesn't mean that doesn't mean they're right or wrong, but But to give it the government stamp of approval,
literally, yes,
we investigated, we know, is egregiously improper.
Totally. Yeah, that'll be in legal. Well, I don't know. Never mind. I'm not a lawyer. I don't know, but I would think that could be something that is used for future lawyers, like in law school, of like, I don't know, maybe even like ethics or whatever, just to be like, hey, look at this and look at something what do you see wrong here? Right. And how could you have made a statement and in a very appropriate way versus the unbelievable habitual line stepping that occurred in this?
Yeah. I mean, that statement is one of the most ridiculous things that I've ever heard a prosecutor say. I mean, just absolutely insane to do that. And the answer should have been, you have your lawyers, say whatever you want to say, but, leave us alone. We're going to prosecute a case. You say whatever you want. But having the DA basically, hold the bag for private civilians by doing that is just insane. Insane.
Yeah. Well, I feel good. I feel like, as usual, you are joy, and you bring me to a place of calm and any kind of, little pitter patters that one may have thinking about, like, having my loop of the fuckery afoot in the Commonwealth of Massachusetts. You are what helps me put a stop on it and say, it's okay. And now I'm prepared for the week and moving forward. And I hope that we have a wonderful week, Mr. Bederow. What time are the Pats playing today?
1:00. This is one of those games like you cannot lose. Tennessee is awful. And the Patriots, dare I say it?
Don't do it.
They're kind of good. these days, and they're getting better, and they have the most cupcake schedule you could imagine. I mean, it's pathetic. At this point, the expectations
Playoffs.
have to be. No, it would be you never would have said this at the beginning of the year, but right now it would be a colossal failure if they don't win 10, 11, 12 games. That's how ridiculous their schedule is. I mean, they've got 2 games left against the Jets, which is, Tennessee. I mean, these teams that are on their schedule are just, wow, they're bad. But that's the benefit you get for having a last place schedule, because the Patriots suck so bad the last couple of years. But they're on it at 1 o'clock. So, watch that. And,
I will.
As far as you saying, bringing sanity to all these cases, one of the things I've noticed, and maybe it's a YouTube thing where everyone, so these court cases, whether they end up in trials or not, they're wars. And in wars, there are battles and there are skirmishes and there are highs and lows and ups and downs. And one of the things that I think a lot of the people who watch this stuff do, it's a mistake. They put so much stock in every skirmish or battle, like that's a win, that's a loss, that this is terrible. There is a long game to these processes, and usually you lose more motions than you win. Certainly when you're the defense. I mean, that's normal. There's a goal at the end, and there are highs and lows, and everybody puts so much stock in every appearance or motion or ruling or this, and that is not how lawyers think at all. It's a long game, and people should think what's happening, not, oh my God, they filed a motion to suppress and they lost, they suck. Those are designed to lose.
Yeah.
There's just so much more going on than what you see at any one given court appearance. It's just, there's so much more.
Yeah. And we all know that from being together for some of us 2+ years, 3, some, from Aiden, 3 years of just speaking on one specific case. So, that it wasn't, they may have lost the battle, but they won the war, and will continue to fight the criminal war. And now we're in the civil war, and civil war in more ways than one sometimes, but
like there's a civil war going on, but that's, I don't get involved in that stuff.
Of course. Well, I appreciate you, and thank you so much for your time, and thank you for bringing me just, exactly what is ordered for a Sunday morning to start this next week in all positivity and light, and let's just put forth what we want from this world, loveys. Keep putting things out that you want to receive back. And I know that, it's easier said than done, but we got this, and we're all in it together. And I appreciate you, Mr. Bederow.
Thank you. Good to see you.
Good to see you too. Bye. Bye, loveys.
Bye.
All right. Great job on the news.
Thank you.
We will, Courtney and I will share what happened when we went to dinner last night, Sunday dinner coming up. And as